Patents, broad or narrow? To appreciate the history of patent law, consider its evolution. European patents for inventions began in the Republic of Venice in 1474 and were formalized in England in the Statute of Monopolies in 1623. Article 1, Section 8 of the United States Constitution gives Congress the power to promote the progress of science and useful arts by securing for a limited time to authors and inventors the exclusive right to their respective writings and discoveries. To put this power into action with respect to patents, the U.S. Congress passed America's first patent law in 1790, which was revised in 1793, 1836, 1952, and 1995. To secure an exclusive right to an invention, the inventor must submit an application to the U.S. Patent Office establishing that the invention is for a new and useful process, machine, manufacture, or composition of matter, or a new and useful improvement thereof. Section 35 of U.S. Code 101, or 35 U.S. Code 101. The invention must be non-obvious, must have practical utility, a characteristic that is more or less presumed for all applicants, and must not have been commercialized or known to the public for more than a year before the date of application. A patent examiner, a governor official who is ideally a lawyer with a strong scientific background, must decide whether to grant the patent. Approximately three-fourths of all applications are granted by the Patent Office. Throughout the 1970s, between 70,000 and 80,000 patents were granted per year. Superscript 2, which reads, of those issued between 1971 and 1975, 51% were granted to domestic corporations, 23% to foreign corporations and governments, 2% to the U.S. federal government, and 23% to individual inventors. This distribution represents a trend in the century toward corporate ownership and away from individual ownership of new patents. Frederick Scherer, Industrial Market Structure and Economic Performance, second edition, 1980. Returning to the text. But in the 1990s, patent applications and the number of patents granted in the United States exploded to nearly 150,000 per year. The successful applicant now receives a 20-year monopoly on the use of the invention. Superscript 3, which reads, in 1995, as part of the agreement establishing the World Trade Organization, the U.S. Congress changed the patent life from 17 years from the date of approval to 20 years from the date of application. The change, which brings the U.S. system into conformity with other national patent systems, arose from the approval of the latest international trade agreement. Returning to the text. No one can use the invention except by its owner's consent. Others who wish to use the invention must purchase the right to do so from the patent holder. The holder may, at his or her discretion, license the use of the patent in exchange for the licensee's patent of a fee known as a royalty. If a patent holder believes that another is using his patent without permission, he or she may bring an action for infringement and seek both injunctive and legal relief. WebNote 5.2. See our website for more on recent developments in patent laws in the United States and other nations, including speculation on the causes of the tremendous upsurge in the number of patents in the 1990s and early 2000s. An inventor who applies for a patent risks more than lawyers' fees. The information in the application is accessible to the public. If the application fails, competitors will be able to freely use the invention described in the application. If the application succeeds, competitors will have a precise description on of the invention, so they can try to emulate it without trespassing on the patent, engineer around the patent. For these reasons, some inventors prefer to rely on trade secrets protection and not apply for a patent. More typically, however, an inventor relies on both trade secrets laws and patents to protect his intellectual property. Patents create an exclusive property right in an invention with two dimensions: duration and breadth. Duration refers to the number of years between a patent's registration and its expiration. For example, most U.S. patents last for 20 years from the date of application. Breadth refers to how similar another invention can be without infringing on the patent for the original invention. To illustrate, the Rubik's Cube is a popular puzzle in which each of the six sides of the cube are divided into a 3 by 3 grid, and each of the cells in the grid is colored. The object of the game is to manipulate the cube in order to align rows of same colored cells. An American court ruled that the Rubik's Cube did not infringe an earlier patent by Moleculon for a similar game using a 2 by 2 grid. Superscript 4, which reads Moleculon Research Corp. versus CBS Incorporated, 872 capital F dot 2D 407 and 409 open parentheses fed dot cir CIR dot 1989 close parentheses, returning to the text.